But just to kind of get the ball rolling, let's go ahead and we have an opening email. Let's see if we can go ahead and get that up there. In my mom's will, it says that I'm her personal representative, which is the same as executor. It also says that I'm her health care proxy. Do I need to get a durable power of attorney too? Or is her will all the necessary paperwork? And that's Stephen. Chad, that's a really good question. I know I've had the inverse of that question given to me many of times. I have the durable power of attorney. Do I need a will? If you would, Chad, kind of explain the nuances of the two and the areas of the purview of each and why they're both essential.
Yeah, absolutely. So Stephen, really, your question all hinges on, is mom still alive? Really, to answer that question, I need to know. If she's alive, then absolutely, she should have a power of attorney if she has the capacity to still create a power of attorney. So, think of this. The power of attorney covers those legal and financial things that exist in our life while we're alive. And then when we pass, that's kind of when that personal representative, AKA the executor, can step in and handle some of those administrative things after our passing. So, anytime anybody will listen to me, I say you absolutely should have a power of attorney.
Absolutely.
And if you don't have one, please get one, because most people don't realize how important it is to have one of those until it's too late.
Until you need it.
Yeah.
And Chad, I jumped right into that email question because I'm too familiar with you, but why don't you, to the audience members that maybe have not seen you, you've been on the show many times, but take a little brief opportunity to tell everybody what you do, how somebody would locate you if they needed to have your assistance.
Absolutely. Thank you, Ted. So, of course, my name's Chad Templeton. I own and operate Templeton Law Firm, downtown Panama City. We exclusively handle probate and estate planning.
Yes.
So everything that deals with powers of attorney and wills and even trusts, to even things such as probate proceedings, which of course is when we need to have some money passed through a court system upon a loved one's death. So, so everything kind of in between, and if you're not sure whether you need anything like that, give us a call. We'll probably help you figure out what you do need.
And that's one of those things, and you already mentioned that, if it's too late, you can't put the genie back in the bottle. These are things that it's better to be proactive and plan and have those things in place, because one of the things that was discussed in that email question was a durable power of attorney. What's the difference between a durable and a regular power of attorney, and why would you need one versus the other?
Well, I mean, it's really a nuanced question there, Ted. So durable, that word durable specifically means it survives your incapacity. So in the event a loved one has a durable power of attorney and then they develop dementia or Alzheimer's, that document is still in place and is still valid. Now, if you have a power of attorney that doesn't have that special buzzword in it called, usually we just may call that a limited power of attorney. Those are, they kind of speak for themselves. They're limited in their nature. Maybe they're limited in their duration. I've done a limited power of attorney where I had a client who's going to be in Italy and they needed somebody to, buy a house for them. So we did a limited power of attorney. They were able to sign those documents and, get it done.
And you see those, like you're saying, a lot of times for specific transactions, but some people will go online, for example, and print off a form and think that they're getting a power of attorney that will be effective for whatever they need. But unfortunately, if it doesn't have the statutorily required language that it's going to be durable and survive incapacity, if you get into one of those situations where your loved one is in the throes of dementia or Alzheimer's or has otherwise lost their capacity maybe because of an accident, you're going to have to go to the courts and have that person declared legally incompetent, which is not a fun proceeding for anyone. They have to go in front of an examining committee and have independent professionals look at them and assess them, and then you're inviting the court system to be very actively involved in your life and what you do. Whereas if you have that durable power of attorney in place, you can decide in advance who is going to make those decisions for you, and you will not have to go to court to deal with those things.
And it's not just intrusive either, Ted. It's also very expensive. I mean, when we look at things in life, I always look at it from a cost-benefit perspective. The cost of getting a power of attorney, a few $100s, dealing with a full-blown guardianship proceeding, you're talking about minimum, $5 grand plus. I mean, I don't even know where to start, honestly.